Hi everybody. Today's Facts in 5 video is all about fiduciaries and firearms. So the first part of that is for folks who do own firearms and ammunition, considerations you need to take into account when choosing who it is that you're choosing to serve as the executor of your estate. And the second part of that is for those who are actually serving as executors or appointed to serve as an executor of an estate. You need to really be aware of the state and federal laws that are in place because you want to make sure you're in compliance with those and don't accidentally run afoul of them. So for the first part of that, again, for those who own firearms and ammunition, when you're choosing who it is that you want to be as the executor of your estate, first and foremost, you want to make sure the person that you're choosing is not a prohibited person. So someone who's not prohibited under either state or federal law from owning or possessing those firearms or that ammunition. So one of the most common categories that people think of that fall into this prohibited person heading is people who've been convicted of a violent crime, or maybe folks who have been convicted of domestic violence offenses. So again, make sure the person that you're choosing to be the executor of your estate is not a prohibited person. Also, even if the person that you're choosing is not a prohibited person, they may just be really uncomfortable with handling firearms or ammunition. So you're going to definitely want to make sure to take that into account as well. Once your executor is appointed, or I should say for those who are then serving as executors of an estate with firearms or ammunition, you're going to, again, want to be very mindful of the state and federal laws that are in place. So, and the first part of that is, again, knowing how you need to store those firearms and that ammunition while the probate estate is ongoing. So it needs to be safe, and that's really the basis for a lot of these laws, is they want to make sure these firearms and ammunition is stored safely. So for example, Connecticut has a law that says firearms and ammunition can't be stored on the premises, or on your premises, I should say, unless they are stored in such a way that a minor child would not be able to gain access to those firearms without permission. So if they're secured or locked in a locked box, that's fine. But if you're not able to store them in that way, you're not legally able to possess those firearms or ammunition, again, on your premises. So again, be mindful of exactly how you're able to store those firearms and make sure you're going to be able to be in compliance with those laws. Second, you're also going to need to make sure that when it comes time to distribute those firearms that you're doing to the beneficiaries of the estate, that you're doing so appropriately as well. It may be a violation of either state or federal law to simply put the guns in the car and drive them over to the beneficiary's house. One, just because you as the executor have to have all the proper permits and licensing in place to be able to transport and possess firearms. And two, you may also be crossing state lines. So even if you're in compliance with the laws of the state in Connecticut in which you're in, if the beneficiary lives out of state, you're going to want to make sure you're in compliance with that state's laws as well, again, when it comes specifically time to transport or deliver those firearms to the beneficiaries. Also, more from a probate aspect, you're going to want to make sure you have a very detailed list of exactly what types of firearms and ammunition you have, because the executor's job is not only to deliver those assets to the beneficiaries once the probate administration is complete, but also while probate is ongoing to provide a very detailed list of all assets owned by the decedent at the time of death, so including those firearms. So you're going to want to make sure you know, did the decedent have handguns, or were they long guns, or were they assault rifles? What type of ammunition do they have? And then also getting an accurate valuation of those assets. So if you're not in a position where you're able to comfortably determine what the value of those assets are, you may need to engage a local gun dealer to prepare an appraisal of those assets for you to be able to report the valuation for probate purposes. So again, just kind of be mindful of all of those things. And last but not least, again, I said that if you're transporting those firearms or ammunition across state lines and such, there's a lot of rules and restrictions. But also be sure that the beneficiary you're transporting them to is also in compliance with their own state laws. Because again, maybe they're not a prohibited person here in Connecticut, but maybe they are a prohibited person in the state in which they're in. in which case you legally can't deliver firearms to them if they're not, again, able to possess them, or if they just don't have the proper licenses or registration requirements met. So all things to be mindful of when you have an estate with firearms in it. And I should say my somewhat admittedly glib advice to most folks is that if you own firearms, the easiest thing that you can do for your executor is not to own them at the time you pass away. So if you're getting to a point where you really don't use the firearms anymore, and you know who you want those firearms to go to, the easiest solution to avoid maybe a lot of these headaches is to just gift those assets to the person that you intend to receive them during your lifetime.